All right, guys. So what I'm going to be talking to you guys today about starts out with the Cannabis and the Controlled Substances Act. Just as a little introduction, as we've learned, you guys know, as a part of the war on drugs, the Controlled Substances Act of 1970, signed into law by Nixon, listed cannabis as a Schedule I drug along with heroin, LSD, and ecstasy, with no medical uses and a high potential for abuse. It was identified in anti-drug programs like DARE. As you guys may remember during grade school and high school, I know I remember the Dairy Bear coming in, and they described marijuana as a gateway drug. So looking at the difference between Schedule 1 and Schedule 2 on the controlled substances, just briefly. So Schedule 1, some examples include heroin, as mentioned before, peyote, marijuana, and methamphetamines. So Schedule 1 controlled substances have no currently medical use or currently accepted medical use in the U.S., a lack of safety under medical supervision, and a high potential for abuse, as mentioned. Substances in Schedule 2 have a high potential for abuse, which may lead to severe psychological or physical dependence. And some examples of Schedule 2 narcotics include methamphetamine, hydromorphone, methadone, oxycodone, and fentanyl. Some others include opium, codeine, hydrocodone. And the methamphetamine that I was mentioning before was ecstasy. Okay, moving on. So just as the introduction, the law that of course we're going to be covering here is 42 United States Code section 812, and these are the factors that I've been speaking about to qualify a drug as a Schedule 1. The biggest thing, high potential for abuse, no currently accepted medical use and treatment at all in the U.S., and of course the lack of accepted safety for use of the drug or other substance under medical supervision. Interestingly enough, there have been the 5 petitions from 1972 to 2011 to deschedule cannabis as a Schedule 1. So specifically what we're looking at today are these petitions and why they've failed. Obviously, we know that across the U.S. there's medical treatment with the use of marijuana. So we're wondering what's going on, and is there still a chance of removal of cannabis as a Schedule 1? So these are the sort of questions we're going to be looking at today. And please, as we are looking at these petitions, like I mentioned, as of August 2018, 33 out of 50 states in Washington, D.C. have legalized the use of medical marijuana. So the 1972 petition. In 1972, NORML, for short, but what is the National Organization for the Reform of Marijuana Laws, petitioned the Bureau of Narcotics and Dangerous Drugs, now the DEA, to transfer cannabis to Schedule 2 so that it could be legally prescribed by physicians. The Bureau of Narcotics declined to initiate proceedings on the basis of their interpretation of the U.S. treaty commitments. In 1994, the D.C. Court of Appeals finally affirmed the DEA's administrator's power to overrule Judge Young's decision. The petition was officially dead at this point. Each of the doctors testifying on behalf of NORML, this membership-funded educational organization that I mentioned, claimed that their opinion was based on scientific studies, yet none could identify under oath the scientific studies relied upon. So the DEA administrator, Constantine, remarked this, and that's what he highlighted as the reason why they didn't get their day in court. So none of the doctors here could testify and point to not one scientific study that they relied on. So this is why the first one here failed. On July 10th, 1995, John Getman and High Times magazine filed another rescheduling petition with the DEA. This time, instead of focusing on the medical uses, petitioners claimed that cannabis didn't have that high potential for abuse that needed under the 42 United States Code, required for Schedule 1 or Schedule 2 status. They based their claims on studies of the brain's cannabinoid receptor system conducted by the National Institute of Mental Health. In particular, they claimed that a 1992 study showed that by using a lesion technique, it established that there are no cannabinoid receptors in the dopamine-producing area of the brain. So, of course, that suggested that the marijuana's psychoactive effects are produced totally differently and by a different mechanism than other addictive drugs such as amphetamine, cocaine, ethanol, nicotine, and opiates. Of course, opiates have opiate receptors in the brain. Well, they focused on proving that marijuana, that there was no cannabinoid receptor system in the brain. So the DEA published a final denial of Getman's petition in 2001. The Court of Appeals upheld the agency's decision in 2002, ruling that the petitioners were not sufficiently injured to have standing to challenge the DEA's determinations in federal court. So since this appeal was dismissed on a technicality, it's unknown what position the court would have taken on the merits of this case, unfortunately. So just a little bit of a side topic. In Lujan v. Defenders of Wildlife, this is where we learned the three-part test. If you're not taking it already, you will, and you're going to learn of that three-part test to determine whether a party does have standing to sue. And in this case, the petitioners were not able to successfully prove their injury in fact in order to have standing. So in 2002, the Coalition for Rescheduling Cannabis filed another petition. The new organization consisted of cannabis patients and other petitioners who could be more directly affected, so in order to have that standing by the DEA's decision. In 2003, the DEA accepted the filing of that petition, and according to John Getman, in accepting the petition, the DEA has acknowledged that the coalition established a significant argument in support of recognition of accepted medical use of cannabis in the U.S. In response to the petition's denial, medical cannabis advocacy group Americans for Safe Access appealed to D.C. Oral arguments were then heard in 2012, and then on the same day, the court ordered the plaintiffs, the ASA, to clarify their arguments on standing. In response, ASA filed a supplemental brief about how Krawitz was harmed by the federal government's policy on medical marijuana due to being denied treatment by the Department of Veterans Affairs. The court ultimately found that substantial evidence supported the DEA's determination that adequate and well-controlled studies proving efficacy in order for cannabis to be removed do not exist. So here again, they're denying due to no adequate and controlled medical studies. Start to wonder what's going on here about the studies. The next one in 2009, and the most recent sufficient one that we need to look at, is Brian Crum filing the rescheduling petition with the DEA in 2009. And he was stating that because marijuana does not have the abuse potential for placement, and because marijuana now has accepted medical use in 13 states at the time, and because DEA's old administrative law judge already determined that marijuana is safe for uses under medical supervision, that the federal definition for Schedule 1 controlled substance no longer applies to marijuana in federal law. And to me, this makes the most sense. This is the most sound argument that I've heard so far in the petitions, and I believe that at this day and time, federal law, must be amended to reflect these changes. So here on the 2009 petition, based on the evaluation, DEA concluded that there was no substantial evidence, once again, because of the three criteria, that it does still have high potential for abuse, and they found this from an Department of Health and Human Services evaluation, that it had a high potential of abuse. Marijuana has no currently accepted medical use in the treatment based on the 5-part test because of the drug chemistry, the adequate safety studies, adequate and well-controlled studies, and no qualified experts and scientific evidence. So they found marijuana lacks accepted safety use, that there was no U.S. FDA approved marijuana products, nor is marijuana or cannabis under a new drug application. Just really briefly on the 2011 petition, Washington State Governor Christine Gregoire announced the most latest one in 2011, asking to reclassify as a Schedule 2, and this one's still pending. So when we're looking at this and we're looking at why are these petitions still failing when there's growing evidence of uses? Well, the first two petitions actually died due to doctors being unable to point to any scientific studies. 1995 was the technicality, no injury in fact. 2002, again, due to no adequate and well-controlled studies. And 2009, in well-controlled clinical trials. So obviously we see the common denominator here. So when I was going across this, I was mind blown at what a simple, well, not a simple, but how every one of them is pointing back to this and what we can do from here. So we're looking at the divide between federal policy and scientific evidence. Of course, ever since it has been placed as a Schedule 1, it's created a myriad of problems facing both the medical and recreational branches of the industry. So many problems were created then. So now we're working to backtrack that mistake, and that's the problem at this point. Because the IRS tax codes don't allow businesses whose product is a Schedule 1 to use banking services, now places that it is legally and medically, these dispensaries are having to run dangerous all-cash operations. Not only that, they must also pay taxes on their gross revenue before expenses, unlike every other business in this country. And that seems a little unfair to me. I mean, tremendously, as we've learned, 88.4% of arrests are for possession alone. This burden financially and just a waste of time on the criminal justice system is outrageous. So one big thing we need to do, people, is educate U.S. doctors on marijuana. I was looking up an article, and someone that was looking at practicing in the future on medical marijuana, they stated there's not one residency program in the U.S. that offers this education. So according to the author from Future Cannabis Product, physicians in New York can get certified. So this is a good example of how we can educate doctors in the U.S. On cannabis and how it works to help people. So these it covers the endocannabinoid system, as we see here. So right now only New York and one other state has a marijuana certification available. That means 31 other states do not. And although they have allowed medical marijuana, they have no formal medical education required. I think making education requirements such as these across the U.S. answers one question of how to make doctors aware so they can learn how to use it better. And with these, using it with various patients, they can conduct better studies from there. And they'll be able to present the Corps in the future with these findings. So just briefly, you know that cannabis can be rescheduled either legislatively through Congress or through the executive branch. Congress has so far rejected all bills to reschedule cannabis. Rescheduling supporters have often cited the lengthy review process. The first petition took 22 years to review. So NORML is advised, you guys, an organization that I was speaking about earlier. They've been with cannabis since 1970, backing it up and advocating for it. And because of all the various reasons, they think, and I also agree, it's time to deschedule, not reschedule cannabis. Although all prior petitions have focused on rescheduling, which would at minimum bring it into federal government's the dishonesty that marijuana lacks that accepted use, we should now focus on federally descheduling cannabis. NORML states that such a change would do little, or such a change to only change to Schedule 2 would do little significantly to loosen these federal prohibitions that are making it so hard for the medical studies to be conducted. It's a long-term goal, but we would like to see it descheduled completely, and arguably you can only do that by federally descheduling it, such as in the proposed U.S. Senate bill. You guys can look it up, 2237, ending the Federal Marijuana Prohibition Act. It'll finally provide the states the power they need to establish their own policy of federal intrusion. So what I would suggest you guys do in order to support these bills, you can take action today. You can take action by visiting the regular NORML website, normal.org/act, or if you even reside in Virginia, you can write your lawmakers in under 30 seconds with an easy action alert at virginianormal.org/act. Start writing a letter today and inform your representative. Urge them to co-sponsor the bill. I'd like to end with, of course, the awesome picture of Elon Musk smoking a joint on Joe Rogan's show. It was hilarious to me. You know, the guy that's sending rockets to space every day is smoking a joint, and obviously, if he's able to do that and smoke one joint in his life, I'm sure we'd be okay. And yeah, like Snoop Dogg says, there are two kinds of people in this world: those that smoke pot and those that should. I hope you guys have learned some from me today and about these petitions and the underlying reasons on why, and I hope you guys will act today. Urge your representatives to do this, you guys. Hope you've enjoyed this. Thank you. See you guys.